Okay, everyone, let's get started. So our next talk is about the legal part. Now, you're gonna hear from a Forbes 30 under 30. She's a lawyer, she's a startup founder. She works days, she works nights, she goes to the gym. She's an all-round professional and startup person, and she knows the pains, and she's talked to accelerators and to investors and to startup founders. So you can literally ask her, I'd say almost everything about startups, almost everything about the law. So I'm going to give it up to Ana-Maria, and I'm going to let her take it over. Thank you.
Thank you very much, Paul. Thank you, everybody. It's very nice to be here. I came by plane from Bucharest, and I'm a little bit tired, so if something is not accurate, please excuse me up front. As Paul said, I'm a lawyer. I work particularly in the startup business area, including investment, IP stuff, commercial, and basically everything. And now I think for 2 months, we're focusing on GDPR because everybody is in a chaos in this area. Today I'll be talking about IP because you're tech startups. And I know that when you have a startup, I think the legal part is the last one you think about. You have the investors, you have the funding of the company, you have marketing, you have growth, you have everything else, and you have accountant because you're obliged to have an accountant. And in the end, if you have some spare time and some money, you'll go and think about the legal part. So, when you pitch, I think that the first question people ask me is if you can protect the idea. Because in Romania, apart from European countries, such as France, for example, or UK, people are afraid to pitch their ideas or to get it in perspective because they're afraid that other people will steal and go and implement it, which is accurate because I have some unsuccessful stories where they pitched. They went on investor meetings one-to-one, and the investor said, oh, it's a very nice idea, bye-bye, and I'll implement it with somebody else because they have the money and have the resources. In Romania, you cannot protect the idea. You cannot protect the idea neither in USA anymore. I think that at global level, you can somehow protect your idea in Hong Kong, something like that. What you can do in Romania is when you have an idea is to protect it just like that. It's something like a workaround. You go to the national authority and you protect your logo, for example. You have the logo of the company and you protect it. You have a name and you register it. It would be a very nice thing to have them in the same package. I mean, when you try to think about a name for the company or for the application, for your idea, it would be very nice to have the same one for everything. The same one for the logo, the same one for the name of the company, and for the trade registry. And this is what I will be talking about in the next 10 minutes, is NDA. Do you know what an NDA is? Do you know when you use it? Like?
For example, when you are negotiating.
All right.
But I've never thought about signing an NDA or pitching
At big level, for example, if you're pitching for 1,000 euros or 2,000 euros, you will see that foreign investors, they will put you to sign an NDA. Because NDA works as a protection for both of you. It works as a protection for you as a startup because you will be sure that your investor will not go and sell your idea to somebody else, and the investor will be protected that you're not going to pitch your idea to another investor who could invest in your company and have the benefits. So practically the NDA works in both ways. What you can do in an NDA, and what I really recommend, is to have an extensive and detailed specification of the product. Not exhaustive, like the investor will come and take it and implement it. No, but to make sure what you're talking, what's your idea, what are the specifications, what are the details, so you can know exactly what he cannot do or say furthermore after the discussion. Because if you say, okay, I'll sign an NDA, that you're not going to talk about what I'm going to pitch you in 2 minutes. And who knows what you're going to pitch and what's the idea. But do you know how an NDA works? I mean, for example, we sign an NDA. I sign an NDA, the investor signed an NDA, we're all very happy. And we have a breach of contract. I'm saying or he's saying to somebody else. What can we obtain from it? How? No, it's a practical question. For example, you sign an NDA and you say, okay, if somebody breaches the contract, you'll give me money. And how do you evaluate the money in an idea?
Isn't it a fixed sum in the contract?
This is what I was talking about. If you want, you can put in an NDA a fixed amount of sum. And it's very nice because, for example, we had NDAs or several contracts, because it's the same specification for all the contracts, all the agreements, where people said, okay, if somebody breaches the contract, you'll give me money, prejudice, damages, claims, whatever you want to call it, and you go to court. And the court says, well, yeah, but at this moment, how do you evaluate it? You don't have a company, you don't have a revenue, you don't have evaluation. How much does your idea cost, and what is the damage? I mean, how can you demonstrate that by breaching the contract, it was a damage to you, and how do you evaluate that damage? And what I recommend is to implement a fixed amount of sum, which should be not that low, but not that big. I mean, for example, I'm pretty sure that no investor will sign an NDA for a breach of contract of 1,000 euros, 1,000 euros, but 100,000 euros, sorry. But I think that for amount of 10,000, 20,000, 50,000, it will be fair enough. And then you can go to the court and say, okay, this investor went and implemented with somebody else, and he signed that if he's going to do that, he'll pay me 5,000 euros. It will be fine. However, in Romania, the investors are very reluctant to it. They won't, I don't know at startup level investors who sign NDAs on a daily basis. Sorry?
Same in the US. They won't sign.
And you just go and pitch, and you have the second meeting and the third meeting, and yes, you know what, I need some more details about this, and how are you going to implement it, and what's the market? Is it B2B, is it B2C, what are your partners? Okay, thank you. Which is not that nice. What can we protect in Romania? Well, you have, if you work in hardware, you have patents and inventions, which are protected for 20 years. You have trademarks. It was an E there, but it was misspelled. And author rights. Trademarks, after you register them, are protected for 10 years, and author rights are protected for 70 years and for lifetime. I mean, if I die, it will be protected furthermore. What do we understand? In trademarks, I think that it's pretty clear. Trademarks are logo, and since October 2017, by trademark, we can also register videos, sounds, and all kinds of connection, because trademarks are not anymore limited just to visual stuff. Even motions you can register at European level. So you can have double protection in Romania and in European. And author rights. In author rights, we also have source code. Actually, in author rights, everything you do is an author right. If it's not a trademark, a logo, everything you do is an author right. If you have emails, if you have contracts, if you have source codes, if you have design, if you implement it, if you do anything, it's author right. And this is my favorite part of it. Do you know, as a general rule, who has the IP when you develop something? Yeah, he knows it because we had a discussion.
Is it at EU level or global?
National level. National level. And it's very interesting because I work very much with foreign companies in Romania. And they have those draft template agreement, employment agreement, and they're like, well, of course the company has it. Well, yeah, no, in Romania it doesn't. And it's very nice because I'll tell you a story. In Bucharest, I think 2 or 3 years ago, we had a company working in software development and wanted to have an investment of somewhere about 3 million euros. They were a startup. The 3 people were founders. They took collaborators. After that, they took employees. And when the investor came, this is the first question he will put you. And who has the IP? Well, somebody. The problem was that they didn't have, they were on the market for 4 years, they didn't have any kinds of IP agreements. Neither with the shareholders, the collaborators, or the employees. Nothing. Because they said that if you work in a place on a laptop and on my command, my IP belongs to the company, which it doesn't, because it belongs to the employee. And it was a very big drawback, one for the investor, because the investor was, okay, but now it's a risk for me. I mean, I wanted to invest 3 million euros for 10%. Now I'll invest 3 million euros for 30%, because it's a very big risk for me, because I don't know who has the IP at this moment, and it's not protected. But what was very interesting is that one of the employees, who was a developer, went to a lawyer when he heard about the company and the potential investment, and he went to the employer and said, well, you know, I know you're going to take an investment, and I know that the IP belongs to me, so I want 5%. Yes. And the idea was that he said, well, yeah, but it's my source code. I worked in the application. I developed a big part of it, and I won't let you use it anymore. What are you going to do next? Yeah, this was exactly the face of everybody. I mean, they were like, what? Turns out we went for a settlement. It wasn't 5%, it was 1% from the investment. And afterwards, he transferred all the IP for the company. What I'm trying to say is that even though you won't consider it up front, the IP, as being very interesting or very problematic in the future, when you have these kinds of investment or something, you can have problems like this. And it was a very big drawback even for the company, because to have an employee who has who wants 1% of the investment is something big. If not, you're going to go to court, and it will take about 4 or 5 years, and say, well, yeah, but he developed, but it was my laptop and all that, and eventually it won't happen. In 5 years, you're going to lose the investment, and the application will be outdated. So, how can we protect the IP? I'll have it in 3 levels, because we're talking about a company, a founding company, which is incorporated, with the employee and with the collaborators. I'm pretty sure that most of you think that if you have a startup and your 3 shareholders and everybody works for the company, the IP will belong to the company. Not quite. The IP will belong to the shareholder. What's interesting is that you cannot assume up front that because you have 30% of the company, just like that, what you're going to do is an exchange for the IP. You need to have a specific clause stating that. I usually recommend, when incorporating a company, to make what I call a shareholders agreement, not an investor shareholders agreement, just a shareholders agreement. Does anybody know what a shareholders agreement is? All right. So, when we incorporate a company, we have articles of incorporation, which is basically the template you find on the internet, and you go to the trade registry and put it there, what you do. Activities, nature codes, headquarters, people, and all that, which is public. Everybody can see that at the trade registry. And you can have in the back what I call shareholders agreement, and in Romania, acord de asociere. What can you say here? For example, you can specify in the shareholders agreement voting rights. vested rights, preemption rights, dilution, management positions, management decisions, revenue, profits. How are we going to make profit? How are we going to make business plan? Who takes the decision in companies in their specific domain? I mean, for example, if you have a company with 5 people and say that one is a developer, one is on marketing, one is on business development, and so on. You can specify in the shareholders agreement that all the decisions will be taken with a majority of 4 out of 5. But for example, if we're talking about business decisions, he will have a voting right, no matter what, even though in the articles of incorporation is not stated. Think about the shareholders agreement as a good practice guide. What would you like to have in your company? How would you like for it to develop and to go on a daily basis? How can you say? For example, if you work in a company, you have regulations for interior and good practice. It's something like that, but just think about it as it's in your company. How would you like it to go on a daily basis? Who would you like to have the decision? Who would like to have the voting rights? And in 1 year, 2 years, 3 years, what is going to happen? Because, for example, if where the problems are in voting rights, because people say, okay, we are 5 people, we have 20% of the company, so we need to vote the same, which is not practically a very good idea because we all have different perspective, we all have different expertise. If it's a business decision, I would pretty much like for me to have the business decision, because if you're a developer, I'm not saying that your conscience is not good, but I'm saying that maybe I might know better. So maybe my decision should be a little bit bigger than your decision. And here you also have the IP clauses, where you can say that every shareholder in the company, for the benefits that he will obtain from the company, will transfer all the IP that belongs to the company and is related to it. What you need to know in Romania is that you cannot have a general clause, like in either of these scenarios. You cannot have a general clause like everything John Doe will do belongs to the company, because it's void and will not produce any effects in Romania. You need to specify it. What John Doe does, like this. Marketing, and you further develop it. Social media, content, graphic, illustrator, and campaigns and all that. If you're talking about tech development, you need to specify for each different product what exactly he does. I mean, you cannot say that John Doe developed the application UIX and belongs to the company. No, what exactly he did in that application. I think the best example is, I think that you've all seen, or the majority of you have seen, agreements in IT services where you have that's a schedule, appendix at the end, what services I render to you in software companies. Something like that. When you have those 4 or 5 pages of specifications, that's what you need to do with every employee and every shareholders. Tailored for their project.
And the PME won't cover these intellectual property issues.
Sorry?
The NDA
Yes.
won't cover these issues. So if I came with a source code from my company and go outside, is not affected by NDA?
Well, it depends what you write in it. I understand your question. It pretty much depends. For example, if I'm a shareholder and I say that what I'm going to do belongs to the company, if I don't have a specific clause which allows me to reuse that code in another application, I cannot do that. And that's exactly for the NDA. It doesn't conflict. This is a transfer agreement of IP from the shareholder to the company, and the NDA is a protective form of the idea or the IP. The NDA does not refer to the IP. I'm not sure if I'm specific. The NDA, no, the NDA refers to commercial secrets, commercial information.
Yes, but if I take something out, what I made as a company,
yes,
and it is my intellectual property, won't I disclose company secrets doing something else with that?
Yes, I understand. It's a different question there. It pretty much depends. As a general rule, you cannot take what you went to the company and go to another company. If it's your intellectual property as an individual, you can do whatever you want with it. But if it's not and it belongs to the company, you cannot do that because, first of all, you have a breach of employment contracts. It's not a problem of NDA here, but more of an unfair competition and disclosure. Because I'm taking secrets from company A and I'll go to company B. We're talking here about unfair competition and trade of secrets. It's not in the NDA area. So, but as a general rule, I cannot do that. However, to be in the more applicative area, you can do that. And people do that on a daily basis. And people do not get, well, they do get caught, but nothing happens to them. And why? Because in the employment agreements or in other service rendering agreements, people do not specify what kind of information are protected, what kind of information are confidential, what kind of information are secured, and what are the procedures. For example, if I work in company A and I have secrets, commercial secrets, sensitive secrets, but the company does not have an internal procedure that protects them, they're not secrets. Because our law, and it's in a national level as well, European level as well, sorry, they say that if I as a company, I don't have interest to protect my secrets, well, they're not secrets anymore, right? So I need to have internal procedures to say what are confidential information, what are sensitive information, how do I protect them, and how do I forbid the employee or my collaborator to go to another company. If he does that as the employee, I have a breach of contract, and I can say that a damage amount, which I really recommend every time to specify the damage amount, and I can go and take money from it. But I need to demonstrate as a company that I put all the effort to protect my information. Because if not, it's information.
But what if a person works for a company and they have no successful costs, but they did sign an NDA?
Yeah.
And then that person possesses intellectual property. That person either resigns or goes to another company, doesn't matter.
Yeah.
But he moves to another company C, and he moves the IP as well. What if, for example, let's say the IP is a source code. What if inside the source code there's something that the NDA protects? What happens then?
The NDA does not protect the source code.
If in the source code there's a secret or whatever, or a commercial secret which is protected by the NDA, what happens if we try to move along with the IP?
No, you'll just have a breach of contract of the NDA, not the IP. The IP is not affected.
Yes, that's what I'm asking.
No, you'll just have a breach of contract of the NDA, and you pay damages for the NDA, but your IP still belongs to you. So you can move it, even though it has secrets.
Then what can you do? How can you eliminate those secrets from the...
Well, basically...
What should you do if you want to use it in another context?
Actually, well, you can't.
Even though it's yours, but because it contains and you just eliminate those secrets
From the source code?
Or from whatever form of intellectual property, doesn't matter.
Well, I think it depends. There are companies, for example, where you work in a complete anonymous way. I don't know if, for example, I as a lawyer, when I worked in a big company, I worked for clients in blind. In blind, I just delivered the template agreements, and I was like, oh, it's very nice. I don't have parties. I don't know the price. I don't know anything. So you can protect yourself in that way. to have it completely anonymous for the employee, but it's very difficult.
I'm not wanting to see this from the employer's perspective. I was sort of saying the employee in this scenario, because the employee possesses that intellectual property, but because that intellectual property contains something that's protected by an NDA, cannot use it in any other context.
Sorry? Why? Well, yes and no, because the NDA is very limited and the IP is... For example, the NDA does not allow me to say furthermore. It doesn't say if I can use it. So I have a breach of contract, I'll pay, and that's all. But you'll see, we'll talk after it, you'll see that the NDA does not protect what you're saying as commercial secrets in the application. IP is something different, it's something you develop, and NDA is something like business partners. The source code is not in the NDA. So it's pretty different. What you need to have in mind is that in Romania, every IP transfer needs to be with money. I mean, you cannot say that for 30%, that shareholder transfers the IP because it will be a void clause as everything else in Romania. You need to evaluate that 30% at a moment, or to find a magical mathematical formula in which you will evaluate those 30%. You can say that, for example, there will be 30% of the minimum share capital, which is €50 in Romania, but you need to evaluate it. At the employee, as I said, what I recommend are IP transfer clauses and non-compete, and non-compete is something I really like. IP transfer clauses, as said, if you don't put it in the employment agreement, it doesn't exist. Furthermore, you need to detail it, every project, everything. What I usually do is to have a very big employment contract, which is the basic, and afterwards you have those schedules and appendix, and for every project that is ongoing and will be further developed, you sign another annex, another appendix, and so on, and at the end you'll have something like that for every project. What you need to know is that, for example, if you're employer-employee, it's the same, and you have a specific, a general clause like the employee will transfer very detailed the IP to the company, and you don't say for which amount of sum, it's void. I mean, for example, if I'm the employer and I have an employee which is paid with €1,000 per month, and I don't specify that from that €1,000 per month, 20% is for IP and 80% is for what he does on a daily basis, because IP is the result of what he does on a daily basis, well, that clause will be void and the IP will belong to him. So if you have this kind of general clauses, good for you. And non-compete. Do you know what a non-compete agreement is and how does it work? I'll take it as a no. In Romania, we have two types of clauses by which we can protect our activity. We have what we call fidelity clause, which is during the employment agreement, I mean when the employee actually works for the company, and everything we do for the fidelity clause, it takes as a salary and is taxed like the same. But what we do if the employee leaves and we don't want him to work for the competition? Ta-da! Exactly. There we have that non-compete clause. The problem is that many people don't know the non-compete clause is not mandatory, is alternative if you want to implement it or not, but in order to implement the non-compete clause, you need to pay the employee for it. Not during the contract, but afterwards. So for example, you have an employment agreement, you have that non-compete clause that after the agreement is terminated, the employee cannot go to competitors for two-year period in exchange of a sum. If, as a company, I don't pay that sum, the employee is free to go. Practically, it's a clause that it is in the contract, but it's not activated until I pay the employee that certain amount of sum, which is not a salary sum. It's tax-free. Not quite tax-free, but something like that. And because it's something, why I'm saying that is because I had clients earlier who had general employment agreement like this. You have a non-compete for 2 years, not go to the competitors X, Y, and Z. In exchange of a sum or something. And he didn't actually pay the employee that sum. He forgot. And he said, oh, okay, it's 2 years, it's there, it's written, he can go. In court, the court said, yes, but did you actually pay that amount of sum to the employee in order for him to not compete and to not go to your competitor? Oh, no, but it is in a contract. Well, yeah, good for you.
Is this sustained by the Romanian
Yes,
code?
it is. Just like this, it's for a maximum 2 years after the agreement is terminated. And the minimum amount of sum for non-compete is an average of the salary the employee had in the last 6 months. And if you don't pay that sum, the non-compete doesn't exist. Practically, it's a trigger for the non-compete. Moreover, you cannot have a general non-compete, neither in IP, neither in employment agreements of any type. I mean, you cannot say that the John Doe employee cannot go and work in the IT sector. Yeah, thanks. Or he cannot go and work in Romania. Yeah, thanks, no. You need to detail it. For example, I have some clients who work in VR and augmented reality sector, where they develop software for neuronal diseases, and their non-compete sounds like it's 1.5 page. Our employee cannot develop geolocation triggering device, virtual reality, something, augmented reality, algorithm, and all that in Cluj, Timișoara, București, Iași, Constanța, and every other city that has more than 10,000 people. Yeah, and been there, done that, you know. And he cannot work for the following companies. And we are aware that the following companies are planning to develop something similar, and we forbid for him to go there. This is how a non-compete agreement should sound like in order to be valid in courts. Why I'm saying that? Because our national system, the law system, is based on the free will of association and of work. And if you have a general clause, for example, to not work in Romania or the IT sector or medical sector or something like that, the court will say, okay, but he's a developer, what to do? Agriculture? Come on. You cannot do that. What you should bear in mind, and why I said exactly those activities, is that you will see lawyers or agreements that specify that the non-compete will be triggered if he works only on the same position in another company, which you can have so many workarounds like this. I have a recent example. One of my clients had an employee who worked as a CEO specialist, something like that. I don't know exactly in the occupation system what exactly the number was for core, but it was in core. And their non-compete was exactly to not work in the same position for another company. And the other company knew exactly the employment agreement, and they took him as an accountant. It's not the same position, right? But he does the same activities.
You know, work around the rules, so like I'm not going to get employed with that other company, but I can work like the
If you write it, yes. For example, I always write my non-compete clauses with affiliates and third parties. Because, for example, okay, I cannot protect all the situation because you can choose to not compete with you directly, but you have a friend who has a company and you work through the company. This is something I cannot protect because it's physically impossible. I mean, come on. But you can have something like have non-compete clauses referring to affiliates. Affiliates is everything I have connection with, or third parties I have connection with. And here we can include family, relations, business relations, and I need to specify them. So I can make it general, but in the same time be very specific. So yes, for example, I can have a certain clause that you cannot render those services, either you as an individual person, in a company, through another company, through a vehicle company, through an affiliate company, or through a third-party company. But still you can have a workaround. So yes, if you really want to...
Another question.
Yeah.
And when an employee refused to take the amount that triggered the non-compete?
No. Once you sign it.
Can we get the questions on the microphone or repeat them? At least I cannot hear them. So.
Yeah.
Thank you.
Yeah.
I said that we should get the question.
Oh, sorry. Okay, got it.
No, it was just a general remark.
Okay.
To IP transfer clauses and non-compete, I had this problem with companies who worked with outsourcing companies. It's the same thing. If you are an outsourcing company, what you do belongs to you, even though we have an agreement. If I don't specify an agreement that what your outsourcing company does belongs to me, it belongs to you. Yeah. And it's very nice when you have a client who already paid, who had a solution delivered, and who sees that solution implemented to somebody else in 3 months. Because why not?
If we have a contract with a company from UK
Yeah.
and they register the contract in UK, do we have to register another one in Romania that says the IP that we produce here, it's theirs, it's not ours, or?
No, because I'm pretty sure that in that case, your governing law is the UK law and under Romanian law.
Yes.
So basically, it's outside the border. You can have something, a mixed one, to say that it's governed both by Romanian and English law.
Mm-hmm.
So if you want to be secured, but that's all. I mean, in this case scenario, it's just in UK, and if they have something with you, they'll go and
Yes.
settle it in UK. This is very interesting. By the way, from this example, it's very interesting because I know that if you have an outsourcing, if you work in outsourcing or in software development, you work with clients that are from outside, and it's very important to see how you're going to get paid, and what is the law that governs how you get paid. Because I have a friend, which is a dear friend of mine, who worked as a software development in an outsourcing contract for a company in Germany. Signed agreements, it wasn't a problem. The governing law was something unsecure because they didn't say exactly which was it. So there you have to go to national legislation, European regulation, and see exactly what law is. In this case, the national court said, well, yeah, you have Germany, Romania, or you just go to Germany. And he was like, okay, so now we're trying to take money from Germany, from Romania, from Germany, and it's pretty difficult. So for example, so if you work on a daily basis with outsourcing companies, I would highly recommend that for some clauses to have a governing law, the Romanian law. You can't do that in a contract. I mean, you can have a contract which is governed by more than one law. For example, we have a general rule, the UK law, but for these clauses and this and this and this, we go by our national rules, and it's fine. And I recommend that because you can have money more easily. Do I have? This is what the NDA, shareholders agreement it was. Oh yes, I think it's the last, yeah. I have 5 more minutes, right. As a general rule, it is not IP related. What I really would like to see in your agreements, everything, are damage claims. And it's like this: due time for payments, breach of contract, and damage and claims. Anything else, okay, you can work around it, you can do whatever you want with it, más o menos, but not in due time for payments. And it's a form of protection for you to say exactly when you're going to get paid, when you're going to get paid, how you're going to get paid, what happens if you don't get paid, what's your interest if you don't get paid on time, what happens if you don't deliver something, or if they don't deliver you the information you need to deliver. Because, for example, when you work with a company, with a client, you design a product based on their specification. If the client does not give you the exact specification you need to implement the product, he will come in 2 months' time and say, well, yeah, but it's your fault the product doesn't work. No, it's not my fault because I needed those specifications needed delivered to me. And exactly what happens in breach of contract, for example, in this case, if your client didn't deliver on time those specifications, what happens and what are the remedies, and what I said, damages and claims. I highly recommend in every project you start to evaluate upfront your work. And you have a breach of contract, if you have a breach of clause, if you have something that doesn't work on behalf of a client, just say, for this work, I evaluate my money at 2,000 euros. Whichever happens, if it's a breach of contract from my client, he will pay me 2,000 euros. And it's very easy in the court, because you already have a fixed amount of sum. Yeah, and you cannot, in court, you cannot challenge for more. It may happen to be challenged for less, because the other party will say, okay, it's excessive, so, but as a general rule, the court will, I think in 90% of the cases, the court will give you the amount of sum you had in that agreement. And it's what I highly recommend, to evaluate your work at the start and say, if this doesn't happen, you give me money, because it's faster. Otherwise, you will need to demonstrate in court what was your time, what was the amount of work you had, what he didn't do and why he didn't do, what's the impact, and you'll take about 2 or 2 years just to demonstrate that in court, which is kind of nasty. And that was it. I hope I didn't get you bored enough. Thank you very much for coming. Thank you very much for listening to me. And if you have questions, feel free.
We have 4 minutes or so for questions. So who has questions? Okay, we have one question here.
Hello. What's the difference between a patent and a trade secret? I've seen some companies registering their IP like this recently, like a trademark secret rather than a patent.
Well, yeah, because to register a patent is very hard. Patents are more technical. I mean, for example, if you work in innovation, think of a patent as something you innovate in that field, as a device, as something you do that didn't work, it wasn't before. Think about it like this: a trademark secret can also be a recipe, and you won't protect the device, but you will protect the method you obtain the device, and it's easier. Because for patents, the registration for patents takes about 2 years, because they need to evaluate and to see if it's new, what's the novelty in it, what's the innovation in it, and afterwards to protect it. So therefore, you specify it as a trademark secret.
Other questions? No? Okay. Thank you, Anna. Thank you, everyone, for joining. Let's give her a big round of applause. And I welcome you to ask Anna more questions in the break. I mean, she's here. She probably can answer them. She's not leaving. Maybe it's free. I don't know.